You've been a prosecutor at the national level and you've prosecuted now at the international level. What are the major differences between the two?
It's, you know, at the national level, it's really, and I don't want to say it's a piece of cake. I don't want to really make it sound like it is nothing. But if you compare this with the international level, it's really very easy. In the first instance, at the national level, you have everything at your disposal. And everything, I mean, you have the police, you have your investigators, the protection of witnesses is perhaps easier, the issue of disclosure, all these things at the national level is really relatively easy. If you want to arrest anybody, you just tell the police to arrest that individual based on the documents that you have, arrest warrants and so on, and the individual is brought before the court. It's not a problem. Compare that with an arrest warrant that has been issued at the international level against the leader of a country. I think we've seen enough examples of that. It is very difficult, even against not a sitting head of state, but against even a militia. Because in these two instances, first, for a sitting head of state, you find that there is protection of that head of state by the state apparatus. The example that I can readily give is, again, President al-Bashir. The warrants have been issued against him, I believe, since 2008, probably. Until now, we're having the difficulty of those warrants being executed. Also, if you look at the case of Joseph Kony, for instance, Joseph Kony's warrant was issued in 2005, probably. Until now, we find that Kony is also being protected by the militia around him, and we've not been able to get him before the court. And if you don't have a body before the court to prosecute, you don't have a case. You cannot have a case. You cannot proceed. There will be no proceedings. So these are the major difficulties that you have at the national level and at the international level. The issue of witnesses as well. Sometimes the witnesses don't even need protection. I have prosecuted cases at the national level in which there was no national protection system in place. We go to the witnesses, they come and give evidence, and they're freely going about their business. At the international level, you find that the difficulties that you're confronted with those witnesses to come before the court. And I have given the example of in the case, Kenya case, in which we've seen the level of witness interference and witness intimidation. Also, the protection of witnesses at the international level becomes more critical. It's really very, very difficult. We try to relocate witnesses, for instance, but you know this is a very extreme measure. You're really interfering with the life of a person, taking them, I mean, it's the last one that we look for to do anyway, this the most extreme, but at the same time you're also disrupting to a certain extent the life of a person, moving that person from one place to another to start a completely new life. So these are all, I mean, all the difficulties that you face when you're investigating and prosecuting. Also, the issue of politicization is a big problem that the ICC is confronted with. Whatever steps the court is trying to take, it's perceived as being done because of political reasons. Even though we have consistently said that we prosecute based on the evidence that we have. We investigate, we get the evidence, and we charge based on that evidence. But whatever we do is politicized anyway. And this also does affect the court to a certain extent, the image of the court, if I may put it that way. The accusations that are being thrown at the court that ICC is only investigating African leaders and African states, when it is those African states that have actually requested for the intervention of the ICC, and we are working and investigating based on our statute and our procedures. is also another perception that has been made, that has been given to the court by the wrong accusations that are made against the court. So there are several difficulties, really, several challenges that you are confronted with at this level, which you don't necessarily have at the national level.
Would you say that we were, as the international community, perhaps a bit naive to expect that a court like this could function with government cooperation when it's government people who are going to be suspected and going to be indicted?
I do not think that it is naivety that the international community had. Maybe perhaps the expectations were too high, that this court will just come and do its work very calmly, and then will receive cooperation from everybody. Perhaps that those expectations maybe were just too high. Because one thing that we should realize is that even though this is a judicial institution doing legal work, we are operating in a very political environment. We intervene in very political environment, which affects, to a certain extent, the work that we do. Some, of course, will want to cooperate with us, to assist us to get the work done, but there are other interests. There are other political interests in which will affect their cooperation, or which will be the reason why they will not want to cooperate with us. And as I said, all the actions that we take, people have the tendency of politicizing those actions. I think it was a good thing, it was a good momentum, it was a good resolve that the international community decided to establish a permanent international criminal court. Because I cannot imagine also a community without the International Criminal Court.
But the International Criminal Court now is under serious fire, and serious issues around credibility and effectiveness. Are we seeing the beginning of the end of international criminal law?
I don't think so. In fact, what I can say is that the International Criminal Court has become very relevant, very, very relevant to our existence. The challenges will be there. They are not going to go away. We have to be realistic. The challenges will continue to be there. But does it mean that if we are confronted with challenges, we should dismantle the whole institution and forget about this? And forget the reasons why this court was established, to bring accountability, to give justice to the victims? Should we give up on that? I don't think so. I believe that the resolve that we had to establish this institution, we should pick up that resolve again, be even more determined in seeing this court in practice, seeing the problems that this court can have, and making sure that we also try to look for solutions for those problems, but pushing ahead. We cannot let the victims down. We cannot allow those who perpetrate these crimes, we cannot allow them to know that they can do this and go scot-free. We should not, and we cannot allow that.
There was a sense at the very beginning of the Kenya cases that the way witnesses were being treated was less than stellar. How do you feel about that, and what ways has that improved since the beginning?
Again, I will say that there are several lessons that can be drawn. Some of the accusations that were made were definitely false against the court, but I would also not say that we did everything perfectly right. I cannot claim to do that. The issue of witnesses, witness protection, witness relocation, etc., is the responsibility of the registrar and the registry, not the OTP as such. But again, we also have a responsibility to ensure that the victims and witnesses unit know about the difficulties that a particular witness is confronted with. We have worked on the relationship that we have had, with the office and the victims and witnesses unit. The registrar has taken some extra steps into bringing in people with more experience on how to handle witnesses. Many steps have been taken by both the Office of the Prosecutor, but particularly in the registry, to ensure that some of the difficulties that we had at the beginning of the case, over time we were able to improve on. And I think this will only is only going to be better as time goes on. As I said, there are lessons that have been drawn. Several lessons have been drawn from the situation, not only in Kenya, but other situations as well. And we are constantly trying to ensure that we improve on the deficiencies that probably we have had at the beginning of the case.
Regarding the witnesses, now that the Kenyatta case has collapsed, those witnesses who have been protected and relocated or whatever, how long will that protection and relocation go for?
As long as it is needed. As long as it is needed. Because the duty and the responsibility of the ICC over persons who probably are in danger because of their interaction with the ICC is before the case, during the case, and even after the case. And the protection that has been offered to those witnesses, especially those who are still willing to come forward, the others, of course, if they decided not to be part of the ICC protection program, that is the decision that they have made themselves. And that is different. But with respect to those who we still think that as a result of their interaction with the ICC, they could be in danger, we will continue to protect them.